Legally Speaking with me, Tarun Nangia. Today, we're taking up a very, very interesting episode. This show is about the issue of the Prevention of Money Laundering Act. A lot of businessmen are curious to know about it. A lot of investors looking at India are curious to know about what this law is, what are the provisions, what are the bail provisions, what are the anticipatory bail provisions, what is the twin condition for bail, and so on and so forth. Today, we have a very eminent lawyer. He's senior advocate Percival Binivoria, who joins us. But he would also like to share he qualified as a chartered accountant before turning to law. So I think he has this flair for numbers, as we say, and he takes up a lot of these PMLA matters also on a regular basis. Allow me to welcome senior advocate Percy Binivoria. Good to see you, and looking forward to some interesting insights from you.
Likewise, Tarun. And
at the outset, there is a lot of talk about anticipatory bail in PMLA. And a few people take recourse to anticipatory bail these days, we see in PMLA. In about the first 2-3 minutes, could you just tackle this question before we move on to the others? Because a lot of people have interest in the anticipatory bail provision.
So look, this has recently been clarified by the Supreme Court. I'll tell you what the confusion is. First and foremost, in any normal situation as well, by normal I mean outside PMLA, which is a special law, I would be very loath to advise anticipatory bail. The reason for that is very simple, which is the moment you make an application under Section 438, you are making a declaration that you have reason to believe that there may be evidence because of which you may be arrested. You are likely to be arrested on accusation of having committed non-cognizable offenses. So the moment you make that declaration, and by implication, that is what you're saying when you apply for anticipatory bail. Now, the issue is that when you do not get anticipatory bail, in the event that you do not get, then you are immediately arrested anyway. So even in a normal situation, it's not recommended. In case of PMLA, even more so, because you have heard about these infamous so-called twin conditions, right? One of the conditions is that you have to show the judge that there are reasonable grounds to believe that you are not guilty. So right there, you have a direct contradiction. Under Section 45 of PMLA, you are arguing that there are reasonable grounds to show that you are not guilty. At the same time, your very application, the inherent premise of that application is that there is evidence because of which you may be arrested on the ground that you have committed a cognizable offense. So that is the reason why anticipatory bail in PMLA is even more difficult. Now, what had happened is that in the famous Nikesh Tarachand Shah decision, Mr. Mukul Rohatgi had argued this. Mr. Mukul Rohatgi had argued this in Nikesh Tarachand in 2017, when he said that, look, unlike some acts like, for example, TADA, which include a specific bar to anticipatory bail, the PMLA Act doesn't contain any such bar. And because it is a bail that you are asking for prior to arrest, right? Arrest is under Section 19 of the PMLA. So the theory was that the twin conditions apply only once you are arrested under Section 19, not before. So the theory was, and in fact, this was one of the reasons why Nikesh Tarachand Shah said that it creates an anomalous situation, because somebody who applies for anticipatory bail doesn't have to meet the twin conditions, whereas somebody who applies for bail in the normal course will have to meet that. So therefore, it is manifestly arbitrary. However, it has been clarified. In fact, as recently as February 2023, there was a decision in the case of M. Gopal Reddy of the Supreme Court, which follows an earlier decision of 2022 in the case of Mr. V.C. Mohan, where it has been clarified that the findings in Nikesh, Tarach and Shah have been misunderstood and misconstrued, and that the twin conditions will also apply in the case of anticipatory bail. So now it's pretty clear. I do believe that was always the situation anyway. But as I said earlier, you have to be a little mindful of the fact that it is a little more challenging than usual. And in the normal course also, anticipatory bail is always the last resort. When you are absolutely sure that there is going to be an arrest, that is when you seek anticipatory bail. In this case, it is even more hazardous.
But now in section 45, which is twin conditions, the judge has to record a finding at the time of a bail that the person before him is innocent, which means before the trial has happened, the judge should feel, the judge should have some belief that he is innocent. Now, at the time of anticipatory bail, the person has not even been arrested. Do you think that makes the his plight even more difficult? That if he goes for anticipatory bail and twin conditions apply, the judge even before arrest has to be convinced that the case per se is not that strong. Could you just clarify this a bit?
Yeah, absolutely. Because as I said, Supreme Court has now clarified that the twin conditions do apply. And you are right. The twin conditions have an inherent problem, which is it is said that the onus of proof is reversed. Normally, you are always presumed to be innocent until proven guilty. Here, it is up to the accused to prove to the court that there are reasonable grounds. But I'll tell you something about these twin conditions. I think a lot has been made about these twin conditions. So I think it's about time that we stop making a song and dance about it, stop wringing our hands. Because look, the Supreme Court, Vijay Madanlal, has said very clearly that there is nothing wrong with the twin conditions. They are constitutionally valid and they are not manifest. There is no manifest arbitrariness. It has also said that there are many safeguards. Now, this is very important because, see, question is, when does the question of bail come in? After arrest? Now, in the correct provision for arrest is section 19. Now, in section 19, the ED has to show that it has reason to believe that the person being arrested is guilty. And it has to reduce such reasons in writing. Now, this also puts an onerous condition on the ED in the first place. Remember, bail comes secondary. So you are going to argue your twin conditions of bail after the ED has met this onus of proof and committed to it in writing. Now, the problem that happens here is it says committed in writing and that the person arrested must be informed. Now, until recently, it was very unusual for the ED to give you the grounds of arrest. So there is a memo of arrest. Annexed to that is the grounds of arrest, right? Which is the reason to believe that the person is guilty, committed in writing. So they used to say that I can just inform you, I don't have to give it to you. Now, if you look at the Vijay Madanlal decision, it says very clearly that there are sufficient safeguards in this provision to make officers accountable about the necessity of arrest. So if the officers have to be accountable for the necessity of arrest by committing their belief in writing, then what is it that they are doing by keeping the grounds of arrest? They can't keep it in the files, right? There is no internal audit system in the ED to make the officers accountable. They have to give you a copy, and it is in relation to this copy. See, this is your frame of reference. You are asking for bail. Somebody arrested you, and now you are saying that, look, the grounds of arrest, where the ED says there is reason to believe, I am saying there are reasonable grounds. So the bar that I am fulfilling is actually lesser than what the ED has already met. And that is your first frame of reference that you have to argue. Of course, what actually happens in practice is that the the prosecution complaint is filed, and after the prosecution complaint is filed, then you are likely to be asked many questions on that. So then the frame of reference shifts to the prosecution complaint. Now the prosecution complaint is on the same footing as a charge sheet. It is filed when the investigation against you is complete. Now, to my mind, it is absolutely wrong to keep a person detained and under arrest in JC after the charge sheet is filed. The only possible justification could be that you are going to abscond and not face trial and not submit to the jurisdiction of the court. But that doesn't really happen because see, who are the people who are in ED right now? These are respected business people who have assets here, family here. They are not the kind of people who are likely to abscond. That brings me to the second twin condition, which is that, and don't laugh, but it says that you have to show that you are not likely to commit any offense while on bail. Now, any offense doesn't mean that you get a parking ticket and you violated this condition. It should be a like offense. Now, what is likely to? Likely to means propensity to commit a crime. So if you're a first-time offender, for example, you are a respected business person, you have a standing in society, then this condition is met. These are all judicial pronouncements, by the way. So that condition is easily met. It is only the first condition with which people have difficulty, which makes them wring their hands. I am saying now, after Vijay Madan Lal, you must insist on the grounds of arrest. If you do that, and your first frame of reference is the grounds of arrest, where the ED's bar is actually higher, the bar is set higher, then what you have to show? Thereafter, when the prosecution complaint comes and the investigation against you is closed, there is no reason to detain you anymore. So the issue really that has been hotly debated by people is after Vijay Madan Lal, which is, of course, the law as it stands today, does anything survive in Vikesh Tarachan? Now, here I have a view, which is that, look, Vikesh Tarachan was based on certain iniquities. For example, Justice Nariman has clearly stated, Justice Nariman and Justice Kaul, that unequals are now being treated as equals. And he gave several examples of that. Subsequently, the law was amended. And all that Vijay Madan Lal says is that now that the law is amended, we do not believe that this is any more unconstitutional and there is no manifest arbitrariness. And as I said, it says that there are several safeguards. But if you look at Vikesh Tarachan, it also discusses not just those iniquities and arbitrariness, it also discusses Article 21. See, Article 21 is the only article that cannot be stopped even during emergencies. It cannot be overruled. Forget about the executive. Even the legislature cannot override Article 21, the right to life and liberty. And Vikesh Tarachan discusses this issue at great length. It also touches upon the 7-judge decision of Maneka Gandhi, 1 SCC 284. Right? It's a landmark decision. He has rightly called it a watershed, which talks about personal liberty. So I do believe that these twin conditions will also be viewed in that context. Now, there are certain gems in Vikesh Tarachan, which I think we can bring out. One is that judges have the ability to look at the gravity of the offense. So somebody is alleged to have committed some offense. Now, the judges have the ability to read into or read down the provisions. This comes from Vikesh Tarachan, right? I mean, it's always been the law, but specifically in the case of PMLA, it is specifically mentioned there. So if you look at the twin conditions and the way the people are going on about it, one would think that, okay, in PMLA, there's absolutely no possibility of bail. That is not the case. People are getting bail today. In fact, there are people who are also getting anticipatory bail, let me tell you.
They are?
Yes, there are cases where anticipatory bail has been granted. So therefore, tell me, how does this happen? It's because this is where judicial discretion comes in. See, the problem is not with the law. The problem is with the manner in which the law is applied. And that is where the judiciary has exercised and will continue to exercise its discretion. You just have to invoke the right issues and use the right frame of reference at the right time. So that is really the key to how to make use of Nikesh Tarachan even now. And as I said, look, Maneka Gandhi decision, which dates back to 1978, is a 7-judge decision. Right? It's a landmark judgment. So there is no getting away from that, no matter what Vijay Madan Lal says. And Vijay Madan Lal doesn't really go into that aspect at all. All it says is the law is amended. It is well accepted that, look, if the judiciary finds something which is an anomaly in a law or finds it unconstitutional because of a particular reason, the law can be amended to get rid of that anomaly, which is what has been done. I agree. Right. So prima facie, there are safeguards. So to that extent, the Supreme Court is right. There are safeguards, but the manner in which these safeguards are to be exercised, it's up to the courts to step in whenever they believe that something, some injustice is occurring.
Now we'll come to another interesting aspect, is that the Justice Khanwilkar judgment, from which review petitions have been filed. What do you think are the issues that need to be ironed out via the review petition or otherwise also? What do you think is the issue there?
Well, there are a couple of aspects that I think we could look at. I don't know whether it'll happen in the review, but let me give you 3 examples. So one of the biggest issue is parallel investigation. So look, as you know, you need a predicate offense, which is a scheduled offense. So there's already a scheduled offense which is being prosecuted by some other agency. It could be the police or the CBI, income tax, right? So that predicate offense investigation is already going on. Then you have the ED, which can immediately commence an investigation. And in the course of investigation, it doesn't look only at money laundering, it also looks at the predicate offense. So you are really in a situation where you are almost simultaneously answering questions to 2 different agencies. Now here there is a major issue because ultimately, if you look at the definition of proceeds of crime is criminal activity related to a scheduled offense. So there's a schedule to the PMLA, if the offense is listed in that schedule, and there is a criminal activity related to that offense and proceeds from that crime, then that is the definition that we are concerned with. So criminal activity. Now, if the CBI has filed an FIR only marks the beginning of the investigation. Now, there may be situations where the FIR may be quashed, or there may be situations where you are acquitted, but at the same time, you have gone through a lot of grief before the ED, because these are parallel investigations. I think this is something that needs to be looked at a little carefully. But the problem is, you see, it's a question of time, because if tomorrow the courts were to say that it is not the FIR, but you have to wait till you are convicted for the scheduled offense, which is really the way it should be. But the problem is that if you do that, then by the time the ED looks into the proceeds of crime, then the assets would be dissipated. It's all gone. So there's nothing left for them to investigate. So this is really a practical problem that, I'm sure that there can be very graceful solutions to that. The other issue really is that, look, when the ED records statements, now in the Indian Evidence Act, there is something peculiar, which is any statement to a police officer is not admissible as evidence. So let's say CBI, they are police officers, not admissible as evidence. But statements to the ED under section 50 subsection 2 stand on the same footing as if it was a statement made on oath before a magistrate. So this is another issue. I won't say it's an issue. I think I'm not saying it's a bad thing. The law is, this is the law, and we have to deal with the law as it stands. Whenever clients are going into the ED and giving statements, they have to be mindful of the fact it is, like in USA, they say that everything you say can and will be held against you. That is the case with the ED. The other issue that, frankly, Vijay Madan Lal could have looked at a little carefully is you look at money laundering. What is the definition of money laundering? It means that you have some illegal proceeds, and then you are showing them to be untainted, to have been derived from a legitimate source. That is the actual meaning of money laundering all over the world. So therefore, if you look at our section 3 in our act, there are 3 elements. One is that there must be a predicate scheduled offense. Then there must be proceeds. There will be some proceeds flowing from that offense. And then the third element is that you are trying to project those proceeds as untainted property. And here in that definition, there is an and. Now, Vijay Madan Lal says that this and should be read as an or. Right? So the long and short of it is, you don't have to satisfy all 3 conditions. Right? So even if you have, suppose, let's take, in Bombay, we have this famous sopari, right? Somebody's taken a sopari. And let's say he's killed somebody and he's been given a princely sum of, say, 5,000 rupees. Right? So that is proceeds of the crime. Now he keeps the 5,000 in his pocket. So he is in possession of proceeds of crime. But he doesn't do anything to project it as untainted property. He is still guilty of money laundering.
Is it?
Yes, because of the fact, there were various ways to read this section, but now Vijay Madan Lal said that and, so it would be conditions 1, 2, and 3. It is not and, it should be read as or.
So it's not robbery, murder and robbery.
Any crime, the proceeds thereof. So if you keep the proceeds with you in your pocket,
it's not robbery,
and you don't try to launder it and show it as untainted property, it is still, you're still under PMLA.
You will be prosecuted for robbery and PMLA both.
Robbery, you will be prosecuted under the predicate offense or murder, right? But as far as the money laundering is concerned, you attract PMLA anyway.
This is a very interesting insight you've given. I think we should do a follow-up of this show on many of the issues which have come in the previous answers that you've given on section 45 on this. But before that, I also want to take your perspective on how the money laundering law has evolved in the West, how the agencies there are working, any analysis that you can give, a composite analysis. There are many nations across the globe, but largely in the Western world.
Yeah. So look, I'll tell you, when I first got into money laundering, when the 99 Act came, I was first interviewed in the Times of India. So there's one broadsheet interview of mine where, money laundering was a new law. We promptly forgot all about that until 9/11 happened. So when 9/11 happened, President Bush woke up one day and realized that a lot of the terror funding comes from money laundering. And they discovered that there was already a law, American law on the statute books, FCPA, right? Foreign Corrupt Practices Act. It was somewhere, I think, 1977. Now that law had extraterritorial jurisdiction. What do we mean by that? It means that if there was an American company which is committing a wrong in any other country outside USA, that is still a crime which can be prosecuted in USA. And sometimes the agents of the American company who aid and abet in that crime can also be roped in. So they discovered that this is on the statute books, and they started to enforce. So I remember it was about 2003, 3 or 4, and I was sitting in New York in the office of a law firm, and they marched in, why don't you meet our new white collar crime partners? And 7 people walked into the room, and I said, what the heck is white collar crime? They just started a new division, and everyone got into the game. In India, the first time it really took off. I mean, of course, we had our own Bofors and everything, but the first time that this corruption scandal really hit the headlines is with the Commonwealth Games. That was the beginning. Then you had 2G and the coal scam and everything. And I've been lucky enough to be involved in some way or the other in all these historical aspects of white collar crime, what is known as white collar crime in India. There are certain differences in which foreign agencies proceed. I think the one main thing, so, when you ask me about what are the problem areas, let me answer in this particular context. So, look, the problem areas have to do with the approach and attitude of the prosecution. It's a prosecution mindset. So there are certain, you could almost say thumb rules, right? So for example, one thing is that when there is an FIR, let's take a plain FIR or ECIR, that marks the beginning of an investigation. Now, if you investigate, if you think about it, it is very likely that you find no reason to prosecute the guy. Right? You've investigated. Now, the result of the investigation could either be, yes, there's something here which can be prosecuted, or no, not really, I don't think so. This will not stand the test of court. And it shouldn't be made to go through a trial. Unfortunately, if you see the percentage of FIRs that are closed, it's abysmal, small percentage. I don't know the exact figure, but very few FIRs are closed because our agencies believe that, okay, once you lodge an FIR, it has to go to charge sheet and then trial, or in this case, an ECIR, and then a prosecution complaint, and then there must be a trial. So this flows from the mindset. Abroad, if a prosecutor fails to reveal exculpatory evidence, because the whole idea is that it is the job of the prosecution to come to the truth and to help the court in arriving at the truth of the matter. So if they fail to point out exculpatory evidence on their own without being prompted, then it is an ethical issue. They'll be hauled up by their bar. Now here, our agencies are very lackadaisical about exculpatory evidence. Typically, a charge sheet will include only evidence which they feel will enable them to frame charges and go to trial. This is one of the reasons why we say trials progress slowly, that ultimately you have acquittal. This is one of the reasons why this happens. So I think some of these issues can be addressed very easily.
Thank you so much on today's show for clarifying each of the issue thread, where in fact, some of the points you've spoken, we've never taken up. So I think that provided the viewers a fresh insight into the PMLA law. We'll again like to revisit this issue with you in the month of April. This issue, of course, the review petitions are going to be heard by the Supreme Court anytime soon. And this has generated a lot of interest from businessmen, investors, and the larger promoter community who want to understand what this law is all about, given that there has been a lot of action. So this has generated curiosity. Appreciate your joining us today. And thank you so very much for sharing all these insights.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.